Justice of the Appellate Division, 4th Department. Hear ye, hear ye, hear ye. All persons having business to do with this court will draw near, give their attendance, and they shall hear.
Good morning, please be seated. The first case for oral argument this morning is People versus Eric Smith.
Good morning, Your Honors. Josh Tonner on behalf of the people. We're asking the court to affirm the defendant's sentence in this case. If the court has any questions, I didn't realize that my opponent was submitting today, and so I'm happy to answer any questions, but we will rest on our papers.
I think we're good.
All right, great. Thank you.
People versus Naomi Cromwell.
Good morning, Your Honors, and may it please the court, Heather Burley for the appellant.
Wait, just,
Your Honors, I bring this appeal challenging.
wait 1 second.
Excuse me.
Okay, go ahead.
Your Honors, I bring this appeal today challenging the sexually violent offender designation for those individuals who are out of state, who have out-of-state convictions.
We understand that.
And, Your Honors, I'm seeking that this is unconstitutional on two bases, the substantive due process and the Privileges and Immunities Clause. No.
Counselor, let me take you to People versus Toledo. In Toledo, the Court of Appeals seemed to make reference to the amici brief there, filed by the New York State Defenders, that said something to the effect of that their view was the legislation was a mistake, and what it meant to do was to grant reciprocity, not just for sex offenders who were registered in their home state, so to speak, the state they were coming from, but also to ensure that if they were a sexually violent offender in the home state, as I call it, they will be a sexually violent offender here. And the legislature appears to have made a mistake by leaving that language out of the second disjunctive clause, whatever we call it. Do you agree that that's the likely mistake?
I do agree. I think that's absolutely the most likely thing that would have happened, simply because under this substantive due process analysis, there's no rational basis for making all out-of-state offenders into sexually violent offenders. It doesn't serve anything, in my opinion. And even the people's offered reason that it would be serving administrative concerns for, lack of paperwork that would have...
So just hold that thought for a second. If you tend to agree with that, who knows what the legislature thought, but okay, hold that thought for a second. Assuming that was the nature of the error, after the eclipse yesterday, we did get a slight view. I hate to rub it in Buffalo, but
We didn't get anything.
I was all clouds.
In any event, but I did some extra research last night, and I started looking at North Carolina law. And I know no one's argued it, but I did come across the fact that I'm pretty sure this crime of which your client was convicted in North Carolina, if I'm reading correctly, she is a sexually violent offender in North Carolina, subject to 30 years of registration. Now when she comes to New York, she's not subject to the essential elements test. No one's made that argument here as far as I know. And now we're going to find she's not an SVO, as I call it, here in New York, even though she apparently is one in North Carolina. If I'm reading the statute correctly, would you say that's another reason to find the statute was irrational? That is, she's an SVO in North Carolina, the state of conviction, but she's not here, and given what Congress intended in the late 90s to ensure reciprocity among the states, would you say that's another basis for irrationality?
I would agree. Just as much as the SVO designation can paint with too broad of a brush, it could potentially, leave people out.
Under-inclusive as well. Over-inclusive and under-inclusive. Thank you for my
Anything
question.
further?
Your Honors, I would just submit that none of the people's potential rationalities to justify the statute will save it. And I would also just like to point out, if there's a question of a facial challenge as applied, or as opposed to an as-applied challenge, this is a recurrent issue in my jurisdiction, and I do understand that there are...
We know it is. Okay.
And,
Yeah, we get that.
With that, I would just, you're all very mindful, of course, so I would rest on my written brief.
Thank you.
Thank you.
Mr. Pisco?
Thank you.
Oh, why don't you come back up? Just, yeah, okay. You know, you can sit, but just stay up here. You can sit though. Okay, go ahead, I'm sorry.
No worries. Thank you, judges. I'm happy to rely primarily on my submission. I'm happy to answer questions. I do want to make the point, and I think that this is laid out in the people's responding brief, but to the extent that this was arguably a mistake by the legislature, there have been other opportunities for the New York State Legislature to correct this alleged mistake, which they have not.
They've basically been told they should, and they have done nothing about it.
Exactly, but I think that's indicative of the legislative intent to have these out-of-state registrable felonies designated as sexually violent offenders by the legislature. Moreover, I do believe, well, I understand that arguably it's not necessarily a fair application. I think we have to divorce what's fair from what's constitutional. And here, I do believe that there is a rational basis for the sexually violent offender designation for the out-of-state registrable felony convictions, insofar as it does ultimately all it'll really obligates is.
Mr. Pisco, I'm sorry to interrupt you, and don't lose your train of thought, but you just mentioned the word convictions, and that prompted my memory on a question I wanted to ask. Vis-a-vis out-of-state sex offenders who are coming to New York, do you agree that the analysis should be based, as you say, on convictions and not on the underlying conduct in the other state, as opposed, you're not going to have a mini trial of what the conduct was, you're going to base it on what the elements of the conviction was or the nature of the actual conviction. Do I have that right, or am I wrong?
Judge, I would agree that it's the conviction that determines when a sexually violent offender designation applies. I do believe, though, in calculating the SORA level risk, that as long as it's clear and convincing, it does not have to necessarily be limited to what the conviction was for.
Do you have anything further?
Judges, just again, I'm going to rely primarily on my papers, but I do think that New York State has a rational basis for which to require these out-of-state individuals to register as a sexually violent offender. One of the main points that I put in my brief, and I can speak to personally, is a lot of times when we get these out-of-state convictions where an individual is moving to New York, the district attorney offices sometimes don't have all the information. And I think that's relevant because, again, what the end result here is not that without that sexually violent offender designation, the defendant, Ms. Cromwell, still has to register. The only thing that designation impacts is how long.
It's longer. We understand that.
But exactly. But my point being, there is a rational basis for that because New York's goal is to protect its citizens from potential or from sex offenders. And in cases where arguably we don't know or we don't have all of the underlying information regarding the conviction, it does make sense to require those individuals that, again, and they have registrable sexual felony convictions to have them register for a lifetime. And that serves a
We understand that.
Okay.
We
So
understand.
I have nothing further, judges. If there's any questions, I'm happy to respond.
Thank you. People versus Adams.
Good morning, Your Honors. James Hobbs on behalf of the appellant James Adams. I think the issue in point one, which is the request for a lesser included instruction, comes down to whether or not that issue would have required speculation for the jury to conclude that the people had not proven that the gun was loaded with live ammunition. I don't think it was speculative because I think it was a principal contested issue that was left open by the evidence. The people had to rely, the people did not recover projectiles despite the fact that there was a wall directly across the street, and they didn't have clear motive or intent evidence that would rule out the possibility of a non-loaded weapon. So they had to rely on opinion testimony and indirect evidence. And the opinion testimony was that these casings found in the gun didn't have the hallmark features that most blank cartridges would have on them, that they were more consistent with live ammunition. But the one person who was qualified as an expert to testify on that said they couldn't testify to that with certainty. The other testified that he had been to many shootings, 10 or 15 shootings where blanks had been fired. So I think the evidence left open this question for the jury, clearly. And I don't think an instruction would have encouraged them to engage in any speculation because they had to resolve this question anyway. It was a material element of the crime. Was it loaded with live ammunition? And so they were going to resolve that question one way or the other. The only difference in instruction on this, in the lesser included, would have made is it would have allowed them to treat that, any doubts they had about that, as a mitigating factor, as something to show that the defendant was, less culpable, rather than as an exonerating factor. If there are any further questions on that point, I'd briefly move to point 2, which was the challenge to the introduction of all of the body-worn camera footage.
Is it primarily the Graves?
Primarily the Graves testimony. I think the footage. I think the other footage sort of exacerbates the issue.
Just a minute.
Yeah, sorry.
I interrupted you twice. I'm sorry, Mr.
That's
Fox.
okay, but I'm interrupting you as well, so go ahead.
What I wanted to ask, and I didn't get it out quickly enough, was with respect to the body cam footage and Officer Graves, it looked to me like sort of the primary legal issue you're raising, and if I have this wrong, don't limit yourself, but is to the hearsay.
I think
There's clearly hearsay on there in terms of what the defendant is doing at the time, and no one's argued res justae here.
that's right.
I'm probably mispronouncing that, but you know what I mean.
I know what you mean.
Yes, you are.
Thank you. I need a Latin expert. In any event, you get my question, I hope, Mr. Hobbs, that is so where do we go with the hearsay thing? And what do we do with harmless error then?
So I don't know that I haven't seen any answer to the hearsay problem. I think that is one of 2 principal problems with the footage. I think there's the hearsay of the officers, and then I think there's also just the prejudice versus probative value of the whole tape, with the defendant arguing and having to be forcibly arrested and so forth. I don't think that's probative of much, and it's highly prejudicial. But turning to the hearsay, no one that I've seen has articulated any basis for this hearsay to come, and I think it is very damaging. It's the officers expressing their opinion of what's seen on the video directly and repeatedly, and that is, goes directly to the issue of guilt. And
I don't see the people arguing any exception to the hearsay rule, nothing along those lines, or that it's not hearsay, getting back to that point again.
I believe that's correct. The question of harmless error, I think the question of harmless error is very simple if you agree with me on point 1 that there's a factual issue about whether or not the gun was actually loaded, and whether there's a reasonable view of the evidence that would allow the jury.
That's exactly where I wondered if you had to go there. You have to win on both issues.
I don't think I have to win on both.
For us to get to the second, we have to think favorably of your first.
It helps. I'm not going to say you have to. I think there's another issue as to what the defendant's intent was, which is certainly relevant to one of the 2 charges. And I think that the video is very damaging as to his intent. It makes him, paints him as sort of a bad person, an argumentative person who's not respectful to law enforcement. And so I think it certainly is harmful there as well.
Thank you.
Good morning. Marty McCarthy for the People. I guess, Justice Kern, I would agree with you with respect to you would have to look favorably on the first issue for this error on the second issue to be not harmless, if you will. But with respect to the video, one, I didn't really think of it as a hearsay issue, and part of the reason why is these individuals testified. So in terms of the video itself being prejudicial, yeah, it is prejudicial, but it was also probative. It was extremely probative of the fact.
Ms. McCarthy, in your brief, however, you do, right at the end of your one, when you address this issue, as I read it, you say, well, in any event, it's harmless error. So the only thing you have to say about the hearsay, as I read your brief, is that it's harmless error. Do I read it correctly?
That would be the only thing I would say about that. But you would have to then determine it was actually hearsay. And in doing that harmless error analysis, you'd also have to factor in the fact that the people were testifying. So you would have to look at, he had the ability to cross-examine the officers. But in terms of its probative value, I'm just going to finish up with that. The video was extremely probative. It captured, visually captured the defendant at the scene of the crime very shortly after the crime was committed. It matched up with the surveillance video of the crime as it occurred. It was the video itself was extremely probative. There are no other questions?
You had the surveillance video and you had the body cam video, plus you had the defendant's actions afterwards showing, evidence of consciousness of guilt. So would you say that's the harmless error analysis basically that would overcome that?
That's definitely part of it. And you would say, well, then why did you need the body cam if you had the surveillance? Well, you did have the surveillance, but the surveillance wasn't ID quality. The body camera is. So the jury was able to see that there was no doubt that that was a defendant because ID was an issue in this case. No other questions? Thank you.
People versus Aaron Bell.
Morning, Your Honors. May it please the Court. I tell you on behalf of Appellant Aaron Bell. There are a number of issues raised here in my briefs. For purpose of oral argument, I'd like to focus with respect to the arguments that request dismissal of various counts, the duplicity for counts 1 and 3, potential defective grand jury proceedings, and the weight of the evidence. With respect to arguments that require a new trial or remittal to the trial court, I'd like to focus on the denial of the continuance, motion for continuance, denial of the suppression motion of the cell phone extraction data, and the fact that at the very least it should be remitted for a ruling on the merits of the suppression of the subscriber information. First, with respect to duplicity, counts 1 and 3 with respect to Ms. Boswell charged attempted murder and assault in the second degree, and they were based upon incidents that occurred on December 20th, shooting incidents. The trial testimony revealed that there were 2 distinct and separate shooting incidents, both of which could have formed the basis for the jury's conviction of either the attempted murder or the assault in the second degree.
Wasn't it continuous?
No, Your Honor, it was not continuous. As a matter of fact, the facts in this case are almost identical to the facts of this court's decision in Boykins, where there was an initial incident where there was a shooting occurred. The alleged assailant, retreated, actually went downstairs here for a while. The victim was able to shut the door, yell out to her sons, and then it was some time had passed before the defendant appeared again. And I think that regardless of whether the timing, there's a question of the timing here, but the timing in Boykins was also very short. And regardless of that, it's the impulse. So there was nothing, if you're talking about the attempted murder, there was nothing that prevented him from stopping at the first instance. So he could have continued if that was his intent, if that's what he was trying to do. But for some reason, he left and went downstairs. And it's the impulse.
Counselor, in Boykins, didn't the defendant leave the actual apartment on that one?
I believe they did, Your Honor, yes. I believe they did leave the apartment, but the testimony in terms of how long time had passed was initially a couple of minutes, but then it was revised to mean it was a couple of seconds went by. So even if they left the house, they they immediately return, kick the door back in. And here we have the defendant going downstairs. The door was closed to the bedroom. He had to go back upstairs, and then there was testimony they kicked the door in. So it's very similar to the circumstances in Boykins.
Okay, we'll look at that.
All right, thank you, Your Honor.
Next argument.
Next, with respect to the argument on the burglary counts and the potential defective grand jury proceedings, I did not have the minutes, but first of all, contrary to the people's assertion, this is not precluded by the subsequent trial, because it's not sufficiency of the grand jury evidence, it's a defective proceedings argument, and again, I don't know, but I suspect because the burglary count did not include the element of unlawful entry, that there may have been a problem there, so we asked the court to look at that, whether it was included in the instructions or whether there was some testimony regarding the key, because my client did have a key to the house. Next, with respect to arguments that request dismissal of certain counts, is the weight of the evidence argument. Here, we point to, on the the attempted murder charge, I mean, we have a conversation between my client and the victim beforehand, which is corroborated by neighbor testimony. That is, if he's going into with intent to, kill, why would he sit down and have a conversation with her beforehand? So that's more consistent with his testimony, that they spoke, an argument ensued, and a struggle occurred over the gun. Also, with respect to that, with respect to attempted murder, is he left again. Why would he leave when she was very clearly alive if his intent was to kill her? So, also on the weight of the evidence with respect to unlawful entry, again, my client did have a key. There was testimony that despite the fact that there was an order of protection, he was allowed into the apartment with the key several times. So we'd ask the court to look at that, and particularly with respect to the credibility of the victim here. She had issues, conceded issues of hallucinations and lying. So, also with respect to the attempted murder charge, we have the testimony is consistent with my client's testimony that he was falling into the hallway. That the victim actually testified that she tripped him and he fell into the hallway. So also asked the court to look at some of the trajectory of the bullets. They're not consistent with walking in and pointing the gun and shooting, and also respect to the placement of the shots as well. Turning now to the arguments that request a new trial or remittal to the trial court. We believe the court erred or abused its discretion in denying the motion for a continuance to extract information from the devices that were provided, I believe, the first day of trial. Contrary to the people's assertion, they were required to turn these over, whether it was under Brady, whether it was under the CPL, or whether it was under the discovery order itself. They had an obligation to turn those devices over. They didn't do so.
If I recall, didn't the trial judge say, look at them, and if you need some more time, then you can have more time, and that never happened. That request never came.
It's true, Your Honor, that he did say, I'll allow you to renew your motion once you take a look at this information, but I think that offer was somewhat illusory because it was the day of trial. The trial was starting that day, and I don't think it's hard to get someone to. It's a very technical procedure. I think even it took the people a while to extract data from my client's cell phone, and I don't think it was realistic to think that he would be able to extract that data in the next couple of days and then be able to review it and then determine whether it was something that was useful for the trial. So I conceitedly don't know if it was done or if we have the devices, but that kind of highlights the problem when denying the continuance at the time to allow that to happen.
Anything further?
Yes, Your Honor, I'd just like to go talk about the overbreadth of the search warrant for the cell phone extraction data. Contrary to the people's assertion, the warrant was not as limited as they make it sound. It was very broad. I think this court's decision in I can't pronounce this. It was Okausnak. Also found a similar warrant to be overbroad. All data and graphic files was what was requested there. So we think that the court erred in denying that suppression motion of cell phone extraction evidence, which was obviously crucial to the people's case. Finally, with respect to remittal to the trial court, the trial court denied the motion to suppress the subscriber information based upon the law at the time, which was that it didn't invoke a privacy interest. That law has subsequently been overturned by the United States Supreme Court, and this court has applied that retroactively and held that he's at least entitled to a termination on the merits of that motion. So we think at the very least it should be sent back for that ruling. And then finally, Your Honor, I'd just like to touch on the harsh and excessiveness of the sentence. My client basically has a de facto life sentence. He's in prison for 40 years. And he will be in his 80s when he gets out if he serves that full sentence. I think for various reasons set forth in my brief that sentence is harsh and excessive. We would ask the court, if it doesn't dismiss the counts 1 and 3 on duplicity grounds, or provide the other relief we've requested, that at least reduce the sentence by running the attempted murder counts concurrently instead of consecutively.
Thank you.
Thank you, Your Honors.
Good morning, Your Honors. Michael Tantillo for the respondent. I will take the arguments in the order raised by defense counsel. Regarding duplicitousness, the alleged duplicitousness of counts 1 and 3, this is a unique case because in this case, unlike most, the jury heard the defendant's express intent of the crime he intended to commit. Just a few hours before, in a text message to a person that he was committing robberies with, that person asked this defendant, "So what are you doing tonight?" And the defendant responded in a text message, "I'm about to kill this woman." And it's just a few hours later that he goes into her house and shoots her. So right off the bat, it's very clear what his intent was. The evidence showed that he went into her bedroom, which was dark. He shot her twice, once in the face, and then he left. As he's heading down the stairs, she's yelling to her children who are in the next room, "I've been shot, call the police." Her testimony is, quote, "The next thing I know," close quote, he's running back up the stairs and he comes back in and shoots her 2 more times. The district attorney asked, "How much time elapsed between the first 2 times you were shot and the second 2 times you were shot?" And her testimony was literally seconds. At that, he then goes into the next room where she had been calling to the children. He opens the door. Both victims' children testified that he extended his arm full length and fired 1 shot and struck one of the children, and then fired, or tried to fire 2 more times, pulled the trigger 2 more times. Fortuitously, no firing occurred because the gun jammed, as he later admitted, and 2 live shell casings were found on the floor right there. Later on, in text messages and actually in statements he made to other people.
He said that he wished that it hadn't jammed. So
he would have killed them all if the gun had not jammed.
We know all that.
You got that. So the point I was going to make is I think this is about as strong a case for a continuous action as you could possibly entertain in a situation like this. Regarding the grand jury proceedings, it's correct that, as counsel states, that the indictment omitted the word unlawfully in the burglary counts. Defendant knowingly entered or remained should have said unlawfully. However, the grand jury minutes have been submitted to the court. The district attorney's office advised me that they were properly charged on that element, and that I expect that that would be found upon a review. And there's a case, People versus Wright, from the Court of Appeals that had the very same omission, and the Court of Appeals stated that as long as the indictment listed the correct title and the section number, that's sufficient. The inadvertent omission of the word unlawfully does not affect the validity of the indictment. Regarding the weight of the evidence, yes, there was significant contradictions in the testimony between the primary victim and the defendant. I would submit that the defendant's testimony was utterly absurd. He fired 5 shots. All 5 shots struck victims. Yet when he testified at the trial, he testified that every single shot was unintentional, accidental, didn't mean to do that. Obviously, his credibility, I would submit, is suspect on that. As you've indicated, Your Honor, there was a motion for a continuance made by the defendant when the additional cell phone and tablet was discovered. It had been turned over by the defendant's ex-wife to the police. Contrary to what the defense says in their argument and in their brief, this was not required to be turned over at the time. We're dealing with the old discovery law, section 240.20.
We understand all that.
You're familiar with that, okay. So in any event, even though it was not required to be turned over, the district attorney said, "I'm going to give you these phones right now. Your expert can go through them. If he can't do that, I'll have my expert do it expeditiously and turn over the extraction to you." On 2 separate occasions, the judge told him, if you need more time, if you need a continuance after you see what's on there, just let me know and I'll entertain your application. There was nothing further.
He was never asked.
So I think I pretty much summarized what I wanted to, Your Honors. If there's anything else you have for questions, I'd be happy to answer them.
Any questions? No.
Thank you very much.
Richard Raleigh Senior versus Stacy Galt. There's Mr. King. So who are we waiting for? Oh, Deborah. Jesse. There we go. Okay. Go ahead, Mr. King.
Good morning. May it please the court, Brad Keem for respondent mother. Initially, it is acknowledged that family court could have done a better job articulating the factors it considered in awarding primary residence to the mother. We maintain, however, family court's order was still sufficient and that in any event, the record is good enough for this court to make its own findings. I believe my brief lays out an analysis of best interest, but there are a few issues I want to emphasize, especially in light of the AFC's. First, family court's determination is entitled to great deference, as this court knows, but especially in this case where family court observed these parties for about a year. And during that observation, the father's inability to control his temper was just everywhere. There's just so many examples. He threw his hat in court. He stormed out of court. Due to such behavior, family court imposed supervised visitation that he didn't take advantage of, which only really hurt the child. But it showed his selfish nature. His misbehavior continued. He had Facebook posts about family court. He warned of a major storm coming, no integrity. I know the court is familiar with these facts, but basically they demonstrate the father's an unpredictable individual who's selfish, and he's not a trustworthy role model for the child. In terms of the quality of the home environment, both parties have issues, as family court indicated. But the father, he says he wants to provide a firm guiding hand for the child. Well, the father has that's kind of scary. The father has a legitimate history of domestic violence, not only abusing physically and mentally the mother, but her son. He admitted to spanking the child, to throwing a remote at the child's playpen. These kind of issues resulted in an indicated CPS report in regard to that incident. In terms of continuity and stability, the child's been with the mother, but for a brief period in June of 2021. Yes, the mother has some mental health issues, but in light of what is going on with the father, that is, demonstrated throughout this record, we submit that this court should give deference to family court's determination and affirm the order.
Mr. King, real quick, as family court noted in the record, these folks have had 20 to 25, something like that, petitions. Is there anything new with respect to petitions that would affect the jurisdiction of this court or this court's ability to decide this appeal?
Not to my knowledge, Your Honor. I have been in contact with my client who is chomping at the bit, I guess, one could say, to file additional petitions, but I think it's important for this court to provide an order and guidance that potentially could lead to these parties stopping their barrage of petitions.
Thank you. Ms. Jessie, could you unmute yourself, please? Thank you. No, you're muted. You need to unmute yourself. Wait, can you do it? Wait until we can't hear you. You have to unmute yourself. You're still muted. All right, we can't hear anything you're saying. You need to be unmuted so that we can hear you. Is there anybody there that would know how to unmute you? We can't hear anything you're saying. Well, until you're unmuted, we can't hear you, so I don't know what to tell you.
Your Honor, if I may, Miss Jessie, if you go to the upper right, there's 3 dots of you're looking at the same screen I am. So the 3 dots, if you press that, you can unmute yourself, at least in my experience.
Should we try to call this later so that you can see if you can figure this out?
Or she's asking about the telephone.
Your Honor, she should call the phone number and use the audio.
Okay, can you call the phone number? Okay, thank you. I've never had this happen. Are you calling?
Mm-hmm.
Perhaps we should recall this later. Okay, we're gonna have to, we'll try to do this later, okay? I'm sorry to put everybody out, but, okay, thank you. In the matter of Landon S., I've never had that happen. Okay, can you please unmute yourself? Sally, can you unmute yourself, please? Thank you. Go ahead.
Thank you, Your Honors. Good morning. I represent Cameron S., who's 17 years of age. Cameron does report that he is doing well, but he did drop out of school prior to graduation, and I believe is struggling with formulating what his future looks like. I do feel like that is in part due to the inaction of the father in addressing his school attendance, which he had knowledge of. He knew that Cameron's failure to attend school was having a detrimental effect on his being able to matriculate from year to year and his success in school.
So counsel, you're asking us to affirm, is that right?
I am.
And the educational neglect with regard to Cameron is just one of the examples of why we should.
It is, Judge. It was the biggest factor specifically affecting my client, but there were definitely other factors. Yes.
Okay.
Thank you.
Thank you.
Gabrielle DiDomenico versus Jacob McWhorter.
May it please the court, Rob Taylor on behalf of plaintiff appellate. Can I reserve 5 minutes for rebuttal?
There is no rebuttal in our court.
Okay. Ultimately, this is, I think, a very, very simple issue. It just comes down to whether or not plaintiff appellant actually had actual knowledge of her injuries at the time she executed the release. Okay? I don't think there's any dispute that the Mangini case is controlling. And by definition, at the time she signed the release, it was less than 2 weeks after the accident. At that time, she had not been diagnosed with a concussion, much less post-concussive syndrome. By definition, again, 4 appointments with a chiropractor at this point. No visits with a neurologist, no visits with anyone else, not with the concussion clinic, nothing. She had no idea that she had a concussion at all, although she did have some neurological symptoms, okay? But again, at that point, 4 visits with a chiropractor. That is all that is known to either plaintiff or defendant. She has no diagnosis of concussion. By definition, with no diagnosis yet by any doctor, neither party can have actual knowledge of this injury. That's very clearly a mutual mistake, okay? And again, as all the case law shows, I would say, honestly, the facts of this are most similar to Mangini itself, which again, is the controlling case. In that case, the plaintiff had some issues with the hip, but at the time, all the doctors thought it was associated with a back injury, okay? Ultimately, later, after the release was signed, it was found out that she actually did have injuries to the hip itself, okay? So again, this is obviously a mutual mistake. Moving on to the second issue, I think this is less important, but again, based on the circumstances of how plaintiff met with defendant's agent, okay, she was unrepresented at the time, she was at a coffee shop, was not given any further information beyond 10 minutes, okay. Is there any questions?
Thank you.
I disagree with the main statement. There was a diagnosis of a concussion, and
By a chiropractor.
By the chiropractor.
Who cannot make that,
who did not what?
who is not qualified to make that kind of.
Well, the main inquiry is, did the plaintiff know that she had these injuries? She did. She talked to the chiropractor about that. She talked later on to the concussion clinic, saying that she had these since the moment of the accident.
She had the symptoms, but did she have the injuries?
Well, she had the injuries.
Well, she had the symptoms that, and the chiropractor attributed to her back and her neck, right? But
Except he said there was a concussion here. So it's not like nobody, this would be a mutual mistake. This would be possibly a unilateral mistake. Now, the Putnam case, I think, addresses this. That came out of this department back in November of 2022. Same facts. In fact, the release tracks that case. Any and all, known and unknown. If, with this sort of thing, I mean, the concussion clinic was almost, I don't know how long after this. These releases need to mean something. And as far as duress, this woman's husband was sitting with her.
I'm not so sure the duress is quite as important as a mutual mistake.
Right. But in terms, I mean, the Putnam case, I think, addresses this on all fours. The language was clear and ambiguous. No one forced her to do this. And frankly, the only person getting the benefit of the bargain, actually nobody's getting the benefit of the bargain on this. I think if you're going to try to vitiate a release, the first act ought to be give the money back. Now, if I sell one of you a gold watch and you don't want to pay for it, I at least get the watch back. That hasn't happened here.
you're saying because you cashed the check, that's an additional.
That's an additional admission. There is nothing, she could have walked out of that, I think it was a steward's shop. She could have just walked out of that. She certainly could have gotten legal advice. All we have to do is watch TV every third commercial.
It does have a bad look, though. I mean, she's in a coffee shop. She's an older person.
I don't remember how.
She's not a lawyer, and this adjuster, says here, sign this thing, you can have $1,000. And it's a case that could be, if you watch the TV, lawyers could be worth a lot of money.
But she, in her own affidavit, admits that she understood that this was going to resolve the case. It's in her affidavit, paragraph 7. So she was aware of that. So there can't be some sort of mistake on this. She could have just walked away, found, again, her husband was there.
We got it.
So, thank you.
Thank you. McCurdy versus Roberts.
Good morning, judges. My name is David Hercola. I'm here on behalf of
Samuel Roberts, the appellant. This appeal is involving an order that was entered against Mr. Roberts, holding him in contempt and directing him to continue to pay maintenance in the amount of $2,987 per month for a period of 3 years post his retirement. Our position relative to that is that essentially twofold. Number one, we believe that in order to have found him in contempt, the hearing was required based upon a total reading of the paperwork that was submitted. And in addition to that, we believe that the reading of the court order itself and the conditions contained therein would have and should have allowed the court to require him to continue to pay Miss Roberts the amount of money she was guaranteed for 3 years, but without essentially double dipping and her receiving both a pension and that amount at the same
So
time.
counsel, so we have a situation here where I believe your client would probably admit that he engaged in some self-help. Instead of following what the divorce papers said, he stopped paying on his own accord instead of asking the court for some relief.
I'm not sure if I characterize it as self-help, Judge. I think that there was a misunderstanding as to what the terms and conditions of the divorce agreement were.
Okay, do you think that that's a reasonable misunderstanding?
I do,
Reading
Judge.
the words on the piece of paper which said, ask the court?
I do believe it's a reasonable misunderstanding, and I also believe that the underlying paperwork raised sufficient issues, given the language in the oral stipulation that was entered in court, allowing for a modification in the event that he was unable to work for reasons beyond his control.
Now, let me ask you this. This is what I'm not really sure from the record. Is he paid off? Did he make full payment of everything that?
I don't believe that the maintenance amount, I believe, is still owed, or whatever the difference is from the date of retirement. As far as I know at this present time, Judge, I'm not.
Yeah, I wasn't sure whether maybe afterwards, he caught up and paid what the.
My failing, Your Honor, I did not
no.
inquire into that prior to
I'm
coming
just
this
asking
morning.
factually. I didn't ask which advice, but I just wondered whether or not he made her whole according to the agreement.
Yeah.
Is she getting her pension?
As far as I know,
allocation?
Judge, yes. I
On
think
both?
even during the course of the somewhat protracted motion proceedings that occurred on this case, she was receiving the New York State pension. And I believe there was another issue regarding a GE pension that turned out to have simply resolved itself. There was a lack of information, but I believe at the end of the day, it turned out she's receiving what she should be from that.
Has he moved to modify the agreement?
Judge, it's our position that the submissions to the court at the time that the response was put into the motion were sufficient to give the court jurisdiction to modify the agreement, which in and of itself allows the court to do that for a lack of employment for any reason beyond his control.
But they didn't.
The court did not,
The court
no,
did not.
they certainly did not.
And now that particular judge is retired, so you have a new.
That judge was the third judge on the case.
Wow.
This thing, yes.
I'm not in charge of the 5th district. So.
It hopped through a few judges.
Right, but you haven't brought a new proceeding.
No, Your Honor.
Thank you.
Good morning. May it please the court, Christopher Powers on behalf of the respondent, Liana McCurdy.
Counsel, so I'm sure if I asked you the same question I asked counsel, whether a defendant engaged in self-help, your answer would be different.
Yeah, I believe that's correct. I think that's pretty clear that the order says he should ask for a modification if one is sought, and he didn't do that here.
Okay, so it's counsel's point, however, that the agreement was ambiguous. Was it ambiguous as to this particular point about seeking the court's assistance in ending his payment of maintenance if he felt that was required, or?
I mean, the order as it's written says, during the same time period, meaning 3 years from the judgment, defendant may seek a modification of maintenance should he no longer be able to work for reasons beyond his control. So defendant may seek a modification. I mean, it's pretty plain as day what it said.
So whether or not he could have continued his employment is not really a factor here. It's did he go and ask the court for relief under that section?
I believe that's correct, Your Honor. If you read the whole order together, the first sentence says that Ms. McCurdy was entitled to a certain amount for 3 years. The second sentence says he could seek modification if he wants to, and he did neither of those things. So he's not paying the amount, nor did he seek a modification. So in our mind, it's pretty clear here that it was unambiguous and he disobeyed the order. And just to address your question a minute ago, to my knowledge, the payments are still owed, as far as I'm aware as well.
Because somewhere in the last day or two, I had some thoughts that perhaps that the contempt was purged, but I went back and looked at the briefs this morning to see if that was in fact said, and I didn't find that. But I was interested in knowing whether or not it was.
Yeah, to my knowledge, it's still owed. So the contempt has not been purged, to my knowledge, at this point.
Counsel, what's the effect of the court not putting that in its order? The court never said in its order, he can purge he has 30 days to purge the contempt. And that's not in the court's order, correct?
It's not in the court's order, that's correct.
And would you like to comment on that? Do you think that has any effect?
I mean, I don't know that it does, Your Honor. I mean, I know there was a hearing on the issue, and it may have been addressed at some point in the oral argument. I don't believe it was, but I don't know that the order is the order.
Well, there wasn't a hearing. Isn't that their whole appeal?
I'm sorry, there was a motion hearing. I mean, for the motion on contempt.
Previously.
Yes. It's not in the order. I mean, I don't know that it makes any difference. The judge can give you time to cure or not, as far as I understand it. I don't know that that's required.
But it hasn't been up to this point?
As far as I'm aware, that's correct.
Thank you.
Any other questions? Thank you.
Thank you.
Pearl Street Parking Associates versus City of Buffalo.
Good morning. May it please the court, Charlie Roberts for the plaintiff's appellant. There's cross appeals here, so my intent would be to address the plaintiff's appeal and then the defendant's appeal in that order. The plaintiff's appeal is with respect to dismissal of Buffalo Civic Auto Ramps B-Car, as referred to in the papers, from plaintiff's breach of contract cause of action, the first cause of action, and then the second cause of action, which is against B-Car only. The first cause of action is for breach of the 1965 agreements, what I'll call them. There's an agreement and a conveyance. The B-Car is a proper party to this cause of action in two parts. First, as an assignee of the agreements, and as an agent of the city. On the assignment point, the agreement between, this is where it may get confusing, but there's the B-Car city contracts and the 1965 contracts. So in the B-Car city contracts, the city assigns its contracts to B-Car, and B-Car accepts them. And so number one, you have that the agreements are assigned and assumed by B-Car. And I think one of the issues that special term got hung up on was some requirement of magic language. And there is no magic language here. It says assigned and accepted. B-Car says accepted doesn't mean assumed. I don't think that argument has any merit. B-Car also argues that there was a series of contracts, and so for some reason that makes the assignment not valid. As the court explained in the, I believe it's Pennsylvania Railroad case, the cause of action accrues when the possession of the property is turned back over. So it was one continuous possession. B-Car was also the agent of the city. That's not disputed in this case. Special term did not address this. And again, it's undisputed, and the cases on agency get into factual issues. I would add in this case there were no depositions at this point for this motion. And the crux of the case is that The middle party works as an agent for the principal party, and there's no question that was happening here. This parking ramp sits below my client's, the plaintiff's property. They were dealing with B-Car on a daily basis. You can even go back to the 1965 agreements that there is an expression in those agreements that a third party may come in and run these ramps.
So talk about the flow of money, okay, if you wouldn't mind. I mean, did B-Car earn money? Did they benefit from this agreement to the tune that they actually earn income from this? Did they pay its own employees?
They did have their own employees. I don't know that this issue is briefed or in the record per se, because again, before any depositions. But B-Car acts as the city's agent. They have their own employees. The revenue goes to B-Car. They're a nonprofit, I believe, set up by the city to run its ramps and parking facilities. And so, yes, the money flowed to B-Car. And then some, between B-Car and the city, how that worked, that's for the next stage depositions in this case. We haven't gotten that far.
What about all the equipment? Was that provided by the city to B-Car, or did B-Car, as part of its responsibilities, have to buy the equipment that we're arguing about now?
Well, one small part of the case is equipment. The bigger case is the condition of the ramp.
Okay.
And so the plaintiff's predecessors in interest in the 60s are the parties that constructed the ramp, basically from start to finish. And then in 1969, it was turned over to the city. So my understanding is that at that point, it was fully functional. Now, B-Car, in its time there, this may be the point you were getting at with the personal property claim, excuse me, they installed their parking and revenue control system, and at the end of their term in the ramp, when it's turned back over to my clients, they advised they were removing that equipment because it couldn't function. It's a network across all the B-Car ramps.
Okay.
So that's one, but that's a small part of this. The damage and the condition the property was left in is, about $10 million.
Right. I'm just trying to see, who would have had the money to make the repairs, like if the money flowed to B-Car and stayed with them, as opposed to the money flowing to B-Car and then going right over to the city. Who would have then had the ability to make the repairs, the funding?
The funding would come from the revenue, and so B-Car could do that. There were larger scale projects that are done in conjunction with the city, where I think it was the 1980s projects that were millions of dollars, and that was put out by bonding. But again, that part is between the city and B-Car. But if you're looking at it just as this ramp, the revenue comes in, and from that revenue, B-Car has to pay to maintain the ramp. That's where that money comes from.
Okay.
If there's no other question on the 65 agreement, the B-Car city contracts that we were talking about, the second cause of action in the complaint is that plaintiffs are third-party beneficiaries to those contracts. A few points on that. Again, the 65 agreements are incorporated into those city B-Car contracts, and B-Car took an assignment. The special terms seem to be focused on whether the B-Car contracts named plaintiffs. They do refer to plaintiffs' predecessors in interest in the 60s. And there were two ramps that had this unique setup, the Seneca 1 HSBC ramp and this one. Those are the two that had reversionary interest coming back to the parties that constructed them. And again, special term was looking for the word beneficiary, and we pointed in our briefs the portion of emails and arguments about that. And that's contrary to the case law. There's no magic language required for that. In fact, the cases say you don't even have to identify a third-party beneficiary. And another point, the special term, I think, where it got confusing is they also, in this discussion, said that the plaintiffs that the contracts may have created the requisite privity. So I think the court respectfully got confused on that point. I'll move over to addressing the defendant's appeal. In this case, it's going back again to the 1965 agreements and what obligation that B-Car and the city, in this case it's just B-Car because they're the party that moved here, sorry, but what obligation they had to maintain the ramp. The agreements are clear that the city / B-Car will have the sole right and privilege of operating the ramp for 30 years, during which time it shall pay all costs of operation and maintenance. I believe special term ruled correctly on this. In fact, I think special term said what the standard is may be unknown at this point or undetermined, but they had an obligation. In this case, on the contractual interpretation, if you look at the 65 agreements, there is this, we'll build the ramp, we'll build it to code, and we're going to sell it to you. You have to pay all maintenance, operation and maintenance costs. And then there's a series of exceptions. And that's the one-year warranty that's discussed in our papers. Defendants point to that and say, well, they knew how to use the right language. But it has to be viewed, I mean, it's literally falls under this broad grant of we'll pay all the costs, provided, however, that there's some exceptions to it. That one-year warranty was because the plaintiff's predecessor constructed the ramp. They had to do it to code and workmanship manner, et cetera. So if something went wrong in that first year, it's a natural provision that you would put in there. The other point on that is that clause, in my opinion, would be rendered meaningless if there was no obligation on the city in the first instance to do it. I think there's some other arguments. I'll move through that and get to some key points here. The plaintiffs introduced expert testimony from engineers, two of them, one on the structural part, one on the mechanical, electrical, plumbing. And they state in clear terms that the defendants failed to maintain a ramp in accordance with industry standards. So at the very least, the court can look to industry standards for what the standard of care is on the defendants. They estimate the required repairs in 2020 dollars are approximately $10 million. This proof was unrebutted by the defendants. Another claim that I think was lost in the shuffle of the special term is that the defendants breached the covenant of good faith and fair dealing. And in that case, the court's familiar with that doctrine. I won't go through the rules, but that's basically what happened here, is by their actions, they're frustrating plaintiffs' expectations of what would come from this contract, which is a ramp that is in appropriate condition when it's turned over. Defendants did not address this, and the special term, I believe, found there were unresolved questions on that issue. Real quickly, defendants also raised a statute of limitations argument. That's the Pennsylvania Railroad Company case and related case law on page 19 of our brief. It's a logical rule that when someone possesses property for this long of a period, 50 years, that the cause of action would accrue when it's turned back over. I mean, a year, 2 years before, they could have done this work, traffic membrane, fixing the concrete, fixing the leaf. So that rule makes sense to me. I think the court's decision on that point was correct. The personal property point, I won't spend too much time on that unless the court has any questions.
You're running out of time, so.
Yep, thank you very much. I appreciate that.
Thank you.
Good morning. May it please the court, Mitch Banis appearing for the City of Buffalo and BCAR. Addressing the defendant's cross appeal first, the court below impermissibly rewrote the parties' contract. Now, the plaintiffs here have asserted claims both in tort and in contract. This appeal involves only whether the plaintiffs have a remedy in contract. In order to determine that, you need to look at what the contract said. And what the contract said was that once the ramp was conveyed to the city in 1969, it had the right to operate it for 30 years, quote, during which period of time it shall pay all costs of operation and maintenance, end quote. The contract said during which period of time, a finite period of time. Didn't say 30 years plus another 20 years if the option was extended. And that period ended on June 30th, 2019. And the obligation, even at that, was only to pay for the cost of maintenance, not to actually do any maintenance. And that obligation to pay for maintenance did not include the obligation to pay for repairs. Elsewhere in the contract, when the parties wanted to impose an affirmative obligation to either undertake maintenance.
Let me just follow up on that. Maybe I'm misunderstanding something. Let's take BCAR out of the equation. It's just the city, for example, right?
Sure.
If that can't be your argument, right? That is, the city only had an obligation to pay, it didn't have an obligation to do? I mean,
Well, that's right.
How do you separate them?
Oh, because if any maintenance was required for the benefit of the city, it had to pay for it. It couldn't stick the plaintiffs with the bill.
But who is going to do it?
Who's going to do the maintenance that had to be paid for by your?
Well, the city could have done it itself. It could also have, for want of a better term, subcontracted.
Hired B-car.
They work out, hired B-car, like it did not only for this particular parking facility, but also its 10 other parking facilities. Got to remember, this was the arrangement between the city and B-car was a global arrangement for all of the city's parking facilities. It was not specific to the plaintiffs or the main place ramp. Nor did the contract require that the city convey the ramp to the plaintiffs in any given condition. Provisions like that are customary in commercial contracts. And again, this is indicated in our brief. This was a contract, or contracts, there's two contracts, analytically indistinguishable for our purposes, but negotiated between sophisticated parties at arm's length represented by counsel. Mr. Roberts talks about expert testimony that was submitted in opposition to the motion. The problem with that is that the expert testimony goes only to whether or not a standard of care was met. It did not go to whether or not there was any standard of care that was part of the party's contract. And as I indicated, during the certainly at least during the period years 31 through 50 of the city's occupancy, there was no obligation whatsoever. Any obligation terminated, regardless of what the obligation was, terminated as of June 30th, 2019. This action was not commenced until 20 years later, and for that reason, the claims are time barred, as any breach could only have occurred during the period during which the obligation existed. Thank you. So say this, and the same holds true for the closure of the Church Street exit in 1987. I won't belabor that point. And Mr. Roberts referred briefly to the parking and revenue control system, or parks in the parlance of the case, PARCS. The issue there is that by the time the city advised the plaintiffs that they were unable to turn over the operating software, the plaintiffs had already bought their own park system. They had already purchased their own software needed to operate the ramp once they took it over. And since it's kind of a cart before the horse sort of thing, the plaintiffs themselves essentially rendered the software that they claim that they should have been turned over at the time of the conveyance. They rendered it valueless. There's nothing that the city did that caused that damage, rather the plaintiffs brought that on themselves. Just very briefly, Mr. Roberts made reference to the Pennsylvania Railroad case. That case is not applicable here. This is not a Pennsylvania Railroad situation. The plaintiffs acknowledge that the city was entitled to occupy the ramp from the time not only that the 1960s agreements were executed, but up until the time the plaintiffs exercised their purchase option, but also to the very moment the ramp was reconveyed to the plaintiffs on June 30th, 2019. The city was not a holdover. There was no, as plaintiffs characterized it, there was no reversionary interest here. The plaintiffs essentially had a purchase option, and their rights derived solely from that contract.
Do you have any further?
No, Judge, I think the issues are otherwise covered, certainly to my satisfaction, in the briefs. If the court has any questions, I'd be happy to address them.
Thank you.
Thank you.
You're going to recall number 300, Richard Brawley versus Stacy Galt. I believe that Attorney Jesse is now going to appear just with audio. My question, perhaps you would know the answer, is does Mr. Keem, is he aware of this? Is he coming back on?
The tech guys should be able to try that, Judge. They should be able to hear us now.
There he is.
He's here. Okay. Ms. Jessie?
Can you hear me, Judge?
Yes, we can now.
I am so sorry, and I appreciate the...
No problem, but why don't you go ahead with your argument?
Okay. The record developed at the trial was indeed substantial. There were a lot of witnesses, many days, but the record failed to support the court's order. Specifically, the court failed to state how the facts developed at the trial factored into its decision. This is deficient. It's my that the matter should go back to the lower court, and the court should fashion a custody order that's supported by the record. Specifically, RJ at the time of trial was a nonverbal 4-year-old who was still wearing diapers. He had significant behavioral needs even at that age. He is now 5 years old. He's in a self-contained kindergarten classroom with push-in services, and his behavior issues continue to be substantial. His expressive language is in about the 7% tile compared to similar aged peers.
Counsel, I mean, doesn't that go to the issue about, the parents' recognition of his significant medical diagnoses here? I mean, I guess I recall reading that the father does not believe that his son is autistic, and mother does, and they disagree on how the child should be treated. And I think the court was aware of that, gave great credence to that issue. I'm looking in air because you're on the phone. I know. So I don't know. Could you talk about that for a second?
Yes, absolutely, Judge. So it is true, and the record sustained that the father was much more hopeful in a typical development for his son. And I know that Mr. Keem expressed that in his brief as well. But Dad was really being alienated by the mother from participation in any of these assessments, specifically regarding his cognitive and behavioral assessment, which was done at Strong Memorial the day before the last day of trial. On direct, counsel asked Dad if he was involved with yesterday's assessment, and Dad had no idea that the assessment was taking place. The ultimate outcome of the assessment, by the way, is that RJ is not on the autism spectrum, and therefore he's a kid with a very severe expressive language delay. So yes, I think that the record is clear that Dad comes off very strong out of the box, but it did not seem to me that the court was able to adequately reconcile all the information provided about mom not acting. He could have received years of speech language services had mom applied for earlier intervention services, which an earlier court, in fact, ordered her to do, and she did not do. And even for pre-K services, mom applied late. She didn't apply until November. The academic year starts in September, and he didn't start until springtime. Additionally, mom excluded Dad really from being involved in any of the early, or I should say lack of services. She told Dad repeatedly that there were in-home services, but she mischaracterized those services. RJ simply did not receive any speech services until he started pre-K.
Okay. Do you have anything further?
I think that the court failed to adequately address the substance abuse issue. It was admitted that there's a history of both parents, and both parents tested positive during the case. However, it was also very clear that mom is in active treatment right now, and she's continuing to use. Dad, however, did successfully get discharged from substance abuse treatment, as well as completing a 26-week DV intervention course.
Now, what you just said, is that part of this record?
It is, Judge.
That he completed those and he's through with treatment, and mom is still in active treatment for active drug use?
Yes, and as a matter of fact, it was very difficult, I think, for this court to parse all the different information that came out. Mom has portrayed dad as a domestic violence partner for a very long time. However, with all of the information that was petitioned by the court, there were subpoenas, there was no evidence, there were no medical records of mom ever seeking emergency care or any care for any of these domestic violence alleged incidents, nor were there any police reports offered to substantiate her allegations.
Okay. Do you have anything further?
I don't, Judge. I hope that this court will send this back to the lower court to make a best interest determination.
Thank you.
Thank you.
Paul Monash-Scalchi versus Piersma and Son Contracting. Did I come close to saying that correctly?
I'm with you.
Okay.
Good morning, Your Honor. Captain Stratton, attorney for the respondent.
One minute, we're just waiting for Mr. Detrell.
I'm sorry, Your Honor?
We're waiting for opposing counsel.
Yes.
Hopefully we'll be able to unmute himself. Good morning. Can you please unmute yourself? Oh, no.
Oh, there you go.
There,
Okay.
yay,
All
okay. Go ahead.
Modern technology. May it please the court, Gaston DeChalia, attorney for the appellate in this case. There's major inconsistencies in the lower court, which I think are very clear. The court, in fact, dismissed the case against one of the individual defendants, Robert Piersma, because the contract between plaintiff and Piersma Contracting was with an LLC. But yet, in the same decision, the court did not dismiss the case against Justin Piersma, father and son. And of course, one of the first things we are asking is that the case be dismissed against both Justin Piersma and Robert Piersma, father and son. The next issue in this case is the fact that there was a default judgment. The defendants moved to open up that default judgment. There's very detailed and clear meritorious defenses set forth in the answer as well as in the supporting affidavit in the motion to vacate. It's all in the record, 7 or 8 or more clear defenses to the case, and there was just no service attempted personally on either defendant. The LLC was served, but they left a copy at a storage facility where their equipment is stored and where it was not likely that the defendants would be found. And in fact, they were not at that facility, which is used 3 times a month to get construction equipment to bring to their various jobs.
Except the Secretary of State was served, Counselor.
Yes, for the LLC, the Secretary of State.
Right, so what's the reasonable excuse for not answering that?
It was received by mail sometimes later, sometime after service, of course. And in the interim, plaintiff and defendant were discussing the fact that the plaintiff did not want to pay for certain extras. There was 2 different extras that the contractor asked for, something to do with having to have a pump truck for concrete and another extra caused by the conditions on the job. He made it clear he would not pay. The work was not finished, so an offer was made to refund, money to him, which the defendants assumed clarified or settled the matter, and thought the matter was resolved, but yet they brought a lawsuit, even though they tendered an offer to resolve the case.
Mr. Petrolia, can you hear me okay, sir?
Yes.
The standard of review is what I want to focus on for just a second. Reading the respondent's brief, they point out that the standard of review vis-a-vis the motion to vacate the default is abuse of discretion. You do disagree?
Well, it's more than just, there has to be a reasonable excuse, and I think there should have been a hearing. I think it becomes an abuse of discretion when the court didn't hold a hearing to determine. In fact, the court found incorrectly that the father had a reasonable excuse when the facts were that was the son's reasonable excuse.
Mr. Petrolia, I'm sorry to interrupt you. My question was the standard of review that our court's supposed to apply when viewing whether or not the court erred below. And your respondent argues the standard of review is abuse of discretion. I think that's typically correct for a motion to vacate a default. And if you disagree with that, can you tell me what the standard of review is?
I can't specifically answer that, but I would have to agree that it'd have to be an abuse of discretion, and I say there was in this case.
Okay, thank you. Is there anything further?
No, thank you.
Thank you.
Good morning. May it please the court. Alex Kratkin appearing on behalf of respondent Paul Maniscalchi. I think that Justice Curran correctly identified that the biggest issue here is whether or not the trial court appropriately utilized the standard of review, which is indeed abuse of discretion.
Well, the appellant argues that there's some mistake that the court made in the facts vis-a-vis the two different individuals. I'm not sure which way to read it exactly, but the way it flows, it first talks about Justin, then it seems to be quoting the father talking about Justin's receipt of papers. Yes, he did ultimately get them. And then there's a key paragraph 8 or 9 that talks about Justin this, and then I that. The appellant says that's wrong, that the I that in that paragraph was referring to Justin, and yet the very first sentence refers to Justin in the third person. I mean, if it's an abuse of discretion standard, what do we do?
I think that certainly based on the submission to the trial court had sufficient briefing on all of these issues. It had proof of service. And then, excuse me, in order to vacate the default, there had to be both reasonable excuse and a meritorious defense. And given that what the submissions were and the trial court's findings, I don't think that appellants have established the first prong of the test. And because, at least with regard to Justin, they did not do so, clearly with regard to the corporate entity, it was served. So at this point, we can't even get to the second prong of the test, which is meritorious defense here. And if we can't get to the second prong, the motion to vacate fails.
So this was just a default, there was no dollar amounts, attached, correct?
Correct. There was, my recollection is, and did not, obviously the appeal itself did not focus on this point, there was a subsequent hearing with regard to damages, I believe.
Okay, and did everybody participate or not?
That I do not know, Your Honor. I was not I was not the trial attorney.
Okay, because I guess my thought pattern was, there's a default, but I think even if you're in default, you are allowed to participate in the damages part of it, and so there's still some room there to either settle the case as there was some discussion of, or participate in the proof of damages or lack of damages. And, so that there might be a way to have this case resolved on the merits after all.
I absolutely agree with you. As a matter of law, that is black letter law.
Okay, but we don't know what happened.
Unfortunately, I don't know the answer to that one.
Thank you.
Thank you.
Michael Mamalito versus Rebecca Conjo. Oh, Justice Greenwood is recused on this matter. Morning.
Good afternoon.
It's going.
I had thought that the appellants were going to be, they asked for time, but then they both decided to submit, and I just found out today. I was on my write-up. It's a beautiful drive. If the court has any questions, happy to discuss them.
Beautiful day for a drive.
Yeah, it was gorgeous. Beautiful.
Or for an eclipse?
Well,
Not
it
yesterday.
would have been a good day for an eclipse, but we got the bad day for the.
I stood underneath a heavy cloud yesterday trying to see the eclipse. All I saw was darkness.
Yeah, nothing.
Nothing.
In your supplemental record, you produced to us a decision and order that appears to be a final judgment.
That's correct.
So isn't this appeal to be dismissed and everything will be reviewed through the judgment down the road?
We would argue that, but the appellants might well argue that because it was decided on summary judgment, they didn't have an opportunity to fully vet all the facts at the time of the hearing, but the court really went over all of the actions of the trustees for 2006 and 2017, so I agree, Judge.
Thank you.
Thank you.
I'm glad you had a nice sunny drive.